strictly a part of the law as a basis for rejecting appeals, rejecting complaints, etc. And here again, there's been a diversity within information commissions, etc., etc. And thirdly, I think there's a broad category where we are going to look at implementation problems. That what are the different sorts of problems that are occurring in terms of implementation of the RTI Act. And this cuts across many things. For example, one of the issues that is going to be discussed in great detail is that even when we get progressive orders from information commissions, and there's been, in fact, if you look at the statistics, it's a very heartening statistic, because I think nearly 80% of the orders of information commissions across the country are for giving information. Yet, very often, this does not result in the information actually being received by the applicant, because the government doesn't, or the public authority or the PIO does not necessarily respond to the order of the Information Commission. So how does one handle this? And there are interesting experiments that have been tried. Of course, the most well-known one is the one from Arunachal, and I'm glad that the Information Commissioner from Arunachal is there, where they've actually used the Act to issue arrest warrants. But there are also other sorts of things. Punjab, unfortunately, is not represented today, but Punjab, for example, has a very strong system of continuing mandamus, where they don't close a case till the applicant or the appellant or the complainant comes and says, yes, we've got the information, and etc., etc. So we will discuss that. So this is one, but there are many other implementation issues which are going to be discussed. I think Shailesh is going to lead a discussion on the structure and the processes of the commissions themselves. I would certainly like to say that commissions should start thinking of their own norms. They should not only have norms about how many cases each commissioner should deal with, but then they should have corresponding norms about what sorts of support systems they need, what sorts of autonomy they need. I won't mention commissions, but I've been told by one particular Chief Information Commissioner that every time he was going to pass an order against the government, he used to first make sure that his staff car had enough petrol, because he was scared that the next day they might cut off his access to petrol and not pay his telephone bills. So obviously that's not a very reliable way of functioning and things like that. Now, all this is being done, why? Why are we discussing these issues? I think there are 3 or 4 reasons which I'd like to put across. First of all, I don't think there's enough of an opportunity, and you'd agree with me, of commissioners getting together and sharing their own thoughts on this at the national level. So, I think this is one opportunity, and we hope to make it an annual feature where commissioners can sit down and discuss among each other and with activists, etc., some of these issues. So it's like a forum. I know that there is a national seminar once a year which has been taking place, but having attended all of them, or most of them, I'm not sure whether there's enough opportunity for all the commissioners to speak out and make their views public. So we hope that this will become that thing. And I've been suggesting to Colin, and he's been sweet enough to at least consider the idea that we should have some of these in other parts of the country. So maybe ask some of these information commissions in Tamil Nadu or Karnataka or Arunachal or Nagaland or Mizoram to host some of these colloquiums, so that people can also move to other parts of the country and meet and discuss this. So this is one point. Second is that this is also a time, we finished 5 years, so you know that there are a lot of new information commissioners who have joined, and new Chief Information Commissioners. In fact, we have at least 2 or 3 of them present, or will be having out here. We were hoping that more would come. So it is also one way in which you can pass the wisdom that information commissioners have acquired over the last 3 or 4 years in an acceptable, non-formal way to the new information commissioners who are coming. These posts are very senior, so it's not possible for you to organize orientation programs or training programs for chief information commissioners and information commissioners. But unfortunately, there is also not an institutional system by which the learning and the wisdom gets passed down. And so far, I haven't seen very many books being written by information commissioners about their experiences. So even a lot of literature is not available. Hopefully, slowly this will build up. So this is the second rationale for this. And the third rationale for this sort of a discussion is that if we could collectively get some consensus on some issues, which might or might not occur, then we can take this forward. We can take it to the government, we can take it to state governments, we can even take it to the people in a larger that thing, and say, look, 10, 15, 20 information commissioners met with 15 or 20 NGO activists and lawyers and collectively felt that this was a strong point. Now, I'm not suggesting that we will necessarily get consensus on all issues or on most issues, but even if we can get a consensus on one or two important issues, then that becomes an action agenda which we can take forward. There's also, of course, the wonderful opportunity of interacting with so many young lawyers. I'm sure they're going to benefit a lot from listening to the information commissioners, and I'm hoping that the information commissioners and people like me would benefit from listening to the thoughts of the young people. My one general complaint about information commissions in India is that by and large, except I think for the Northeast, all of us who are involved with the RTI movement are too old. So I feel that we should have a 50% quota in every information commission for people who are under 45. Because you need wisdom, but you also need energy. And we have to have a mixture of the young and the old. At the moment, it's a little old-oriented. And all I can say is that I'm not a youth, but I still hope I'm youthful. But I think we need to actually get youth into the movement, into the commissions, into this whole thing so that it gets energized. Now, we were planning to get your feedback, but we'll do that a little later. Justice Shah has arrived, and I don't want to impose upon his time. So, Colin, can I hand it back to you, and then after we'll come back to a feedback on the session.
I don't think Justice A.P. Shah really needs any introduction, but to introduce to you all Justice A.P. Shah, who all of us know as the judge who gave the judgment in the judge's case. And I think it was reported in the papers yesterday that Justice Sudarshan Reddy has, I think, referred the case to a larger bench in the Supreme Court. It takes me great joy to have him here today. He is to go to London very soon, and I sort of persuaded and insisted that he come. Thank you very much for coming, sir. Please.
If you don't mind, I'll
you can sit here.
Please pardon me. I won't be see, what I just propose to speak about 4 or 5 aspects. One is the origin of the concept of freedom of information. Then the right to information, how RTI, according to me, it was a people's movement, which finally translated into RTI. Then the legal history, I would like to refer to 2 judgments, and then the backlash of from the bureaucracy, from the executive, and unfortunately also from the judiciary. And then I would just like to say a few things on the further expansion of the law, and lastly the working of the information commissions. So this is broadly, this is what I have prepared. Let me begin with an observation of Thomas Emerson. In his classic commentary on the First Amendment, he said, "To cut off man's search for truth or his expression of it is thus to elevate the society and the state to a despotic command and to reduce the individual to the arbitrary control of others." In 1946, the UN General Assembly adopted Resolution 59-1. We stated that, and I quote the words, "Freedom of information is a fundamental human right and is the touchstone of all the freedoms to which the UN is consecrated. Other international human rights conventions such as UDHR, ICCPR envelop the right of access to information within the broader and fundamental right of freedom of expression. both conventions speak about right to receive and impart information and ideas through any media and regardless of frontiers. In Commonwealth, the issue of access to information was first given expression in 1980 when the Council of Law Ministers issued a statement that the public participation in the democratic and government process was at its most significant when citizens had adequate access to information. In 1999, it gave more detail to the right to information. An expert group was appointed by the Commonwealth countries, which confirmed that, and I will quote the words, freedom of information should be guaranteed as a legal and enforceable right, permitting every individual to obtain records and information held by the executive, the legislative, and the judicial arms of the state, as well as any government-owned corporation, and mark the words, and any other body carrying out public functions. Judiciary is not exempt from the application of the RTI Act. And the expert report recommended that it should be also, this obligation to furnish information should also apply to any other body carrying out public functions. I'll speak about it a little later. Now, there are certain principles adopted by the Law Ministers, Council of Law Ministers, and these principles were formulated when we stated that A, member countries should be encouraged to regard freedom of information as a legal and enforceable right. B, there should be a presumption in favor of disclosure, and government should promote a culture of openness. C, the right to access to information may be subject to limited exemptions, but these should be narrowly drawn. Government should maintain and preserve records, and in principle, decisions to refuse access to records and information should be subject to independent review. The ministers called all the Commonwealth countries to promote these principles among its member states. But in India, it came only because of some small workers fighting for their wages in Rajasthan. I would like to, it's a very inspiring history. Mr. Shekhar Singh was a part of this movement. It all began in 1990 when this Mazdoor Kisan Shakti Sangathan, MKSS, a collective of farmers and laborers was formed in Devdungri, a Rajasthani hamlet. Members of the collective were working for a state employment generation scheme, yet were being paid significantly less than the guaranteed minimum wages. On demanding their legal entitlement, they were told that the official records did not reveal their names having done any work. Access to these records was denied ostensibly because they were